Jeypraba Veerapan, and today I will be critically evaluating the considerations taken by the courts in determining the application for postponement of possession order in the absence of concrete evidence from the mortgagor. But before that, we need to understand a few basic concepts first, starting with the definition of mortgage. A mortgage is basically a security for a loan. In Sentley and Weil, 1889, mortgage was defined by Lord Justice Lindley as conveyance of land as a security for the payment of a debt. The two types of mortgages under the Law of Property Act 1925 are legal mortgage and equitable mortgage. A legal mortgage is created when a mortgagor owns a legal estate and mortgages it to obtain a loan. An equitable mortgage, meanwhile, is created if it falls under three circumstances, which are when the mortgagor originally has only an equitable interest in the land, or when the mortgagor has a legal interest but the formalities to create a legal mortgage is incomplete, or when a title deed is deposited for a mortgage. The assignment question focuses on the rights of the mortgagor and mortgagee, particularly with regards to the right to possession. In relation to dwelling houses, mortgagees usually exercise their right to possession as a prelude to sale. Mortgagees might also seek possession of the property to manage it in such a way that so as to generate income to satisfy the mortgagor's defaults. It is important to note the difference between a legal mortgage and an equitable mortgage when it comes to the right to possession before we dive deeper into this topic. According to Lord Eldon in Ex Parte Right 1812, an equitable title to a mortgage was in equity as good as a legal title. This is only partially true when it comes to right to possession, as it was suggested in Barclays Bank Limited and Bird 1954 that possession can only be taken with a court order when it comes to equitable mortgages. The exercise of a right to possession is slightly different when it involves legal mortgages, as the mortgagee would have an immediate right to possession the moment the ink is dry on the mortgage, as demonstrated in Four Maids and Dudley Marshall 1957 and Ropili Jack and Barclays Bank 1999. A legal mortgagee may take possession of the property even if the mortgagor is not in default subject to any contrary provisions in the mortgage. Here, the mortgagee may obtain possession in virtue of the right of the mortgagee instead of in virtue of a remedy to ask for from the court, as is the case with equitable mortgages. If a mortgagee decides to exercise their right to possession of a dwelling house, Section 36 of the Administration of the Justice Act 1970, as amended by Section 8 of the Administration of the Justice Act, provides protection to the mortgagor. Under Section 36, an application by a mortgagee for possession of a dwelling house may be suspended, adjourned, or postponed by the court in its discretion if it appears that the mortgagor would be likely to be able to pay within a reasonable period any sums due under the mortgage. In determining whether a property can be considered a dwelling house for the purpose of Section 36, the case of Royal Bank of Scotland and Miller 2001 can be referred to. In this case, it was held that a reference to the state of the premises at the time the order for possession was sought is the determining factor of whether a property is a dwelling house, and not a reference to their use at the time the mortgage was executed. Now, I will be discussing the considerations taken by the courts in determining the application for postponement of possession order in the absence of concrete evidence from the mortgagor. The Court of Appeal in Cheltenham and Gloucester Building and Grant 1994 refused to lay down rigid rules as to how judges may interpret Section 36 of the Administration of the Justice Act 1970. According to Lord Justice Nourse, judges must be able to act without evidence, especially when when the mortgagor is present and available in court to be questioned, and no objection to the reception of informal material is made by the mortgagee. Here, an income and expenditure list and explanation of the past default may be sufficient as considerations. Practical analysis of the situation is also desirable. Ideally, there should be a witness statement, or the judge may also hear brief evidence in exercising discretion under Section 36. It is important to note that prior to the case of Cheltenham and Gloucester Building and Nourse 1996, the courts will generally suspend possession for 2 years, even though Section 36 does not outline such time limit. This stance was challenged in Nourse, and it was held that a reasonable time period depends on the circumstances of each case. More importantly, Nourse also recommended a more effective use of Section 36 to protect mortgagors, where courts should address a number of issues in deciding whether to exercise their discretion. This is to ensure that particular circumstances of the mortgagor are considered thoroughly. These considerations include how much the mortgagor can afford to pay given his other commitments, whether the mortgagor is in temporary difficulty, or whether his problems are more enduring, what are the reasons for the arrears, how much of the original mortgage period is left, how long the particular mortgagee could reasonably be expected to wait for repayment of the arrears, and finally, how the value of the land relates to the amount borrowed and now owed. Basically, these are the other considerations that can be taken into account by the courts in determining the application for postponement of possession order in the absence of concrete evidence from the mortgagor. Although it is commendable that the Court of Appeal in Nourse laid down that the courts need to carefully assess individual circumstances rather than adopting an institutional mechanical approach to its discretion by covering virtually all eventualities, the effectiveness of the considerations provided in Nourse must also be analysed. The first consideration is how much the mortgagor can afford to pay now and in the future. In order to determine current affordability, the courts would need to examine the mortgagor's monthly income and expenditure. This can be done by calculating the discretionary income of the mortgagor, which is basically the amount of income left after taxes and daily expenses are deducted. To be fair, it would be desirable for the courts to only allow a postponement of possession if there would be a reasonable amount of discretionary income left for the mortgagor after they pay mortgage installments monthly. In Nourse, the respondent argued that given the number of these cases which come before the courts every day, there would be unnecessary cost and delay if the court is required to undertake a detailed inquiry on the ability of the mortgagor to maintain repayments. Here, the court held that analysis of such detailed budgets is part of the expertise in which the district judges have already become adept in their family jurisdiction, and that it would not present too much difficulty. The second consideration is what the reasons are for the arrears, and a closely related third consideration is whether the mortgagor is in temporary difficulty or whether his problems are more enduring. In assessing the second and third considerations, the courts can refer to the Council of Mortgage Lenders statement, which outlines the current practice of mortgage lenders when dealing with mortgage arrears and possession cases. Here, examples of temporary difficulties include temporary shortfall of income, for example, because of an industrial dispute or a temporary illness. Here, it is desirable that the courts allow for a postponement of possession if there is a prospect of full payments being resumed in the near future. However, if a borrower is unable to afford anywhere near the full mortgage repayments because of a permanent reduction in income, and there is no early prospect of a change in the situation, the court should not allow for a postponement of possession, as this would be unfair to the lender. Next, the fourth consideration is how much of the original mortgage period is left. In the case of Nourse, Lord Justice Wade stated that he does not see how the mortgagees can say that it is not appropriate to take into account the whole of the remaining part of the original term when assessing a reasonable period for the payment of arrears. In the same case, Lord Justice Evans stated that when an interest payment becomes overdue and the courts put aside accelerated payment provisions, the lender would be disadvantaged because they are not receiving interest on the capital sum outstanding, and it becomes necessary to consider whether a reasonable period for the borrower to make good the default could extend to cover the whole of the remaining part of the original term, or whether the starting point for fixing that period should be a shorter and even perhaps a conventional number of years. Lord Justice Evans then proceeded to say that it is not possible to establish any reasonable period for the mortgagor to make good the default without taking into account how long the original period was. Lord Justice Evans made reference to the observation of Lord Justice Scarman in Middlesbrough Trading and Mortgage Corporate Limited and Cunningham, 1974, that one begins with a powerful presumption of fact in favor of the period of the mortgage being the reasonable period. This would apply to repayment of the outstanding principal and future interest. As for repayment of arrears, Lord Justice Scarman stated that those arrears should be paid under the judge's order well within the stipulated period for the repayment of the mortgage by the agreed installments. Thus, it can be said that it is perfectly reasonable for the courts to take into account how much of the original mortgage period is left in considering postponement of a possession order. The fifth consideration is how long the particular mortgagee could reasonably be expected to wait for repayment of the arrears, bearing in mind that the mortgagee could be asked to wait even longer than the original mortgage term. In Nourse, the respondent argued that the delaying powers under Section 36 of the Administration of the Justice Act 1970 poses a substantial interference with the contractual right which the parties have themselves freely negotiated, namely the right of the mortgagee to repayment in full of the whole mortgage debt as soon as a default occurs. The respondent contended that the court must balance the claim of each side by considering that the mortgagor should be allowed a proper opportunity of making good his default, while also considering that a mortgagee who has contracted for a steady flow of interest punctually paid by installments should not be compelled to wait for payment through an enforced capitalization of interest. Here, it is absolutely reasonable that the courts consider how long the particular mortgagee could reasonably be expected to wait for repayment of the arrears. It is important to note that the position taken by the courts usually favors the mortgagor at the outset. However, this does not lead to a total disadvantage to the mortgagee because if the new installments initially ordered as a condition of suspension are not maintained and falls into arrear, the mortgagee can then be heard with justice that the mortgagor had his chance, and that Section 36 should not be employed repeatedly to compel a lending institution to accept assurances of future payment from a borrower in whom it has lost its confidence. The last consideration provided in Nourse is how the value of the land relates to the amount borrowed and now owed. If the case is one where the interest might reasonably be capitalized, depending on the borrower's likely ability to pay the increased amount of interest installments, then the principal sum will be increased and the arrears extinguished accordingly. In all cases, the value or likely future value of the security will also be relevant. There can be cases where the value of the security may be threatened if the repayment period allowed is too long. Thus, it is also perfectly reasonable to take into account how the value of the land relates to the amount borrowed and now owed and whether this would cause injustice to any of the parties. In conclusion, The usage of the considerations suggested in Cheltenham and Gloucester Building Society and Norgan 1996 in determining the application for postponement of possession order in the absence of concrete evidence from the mortgagor are comprehensive and reasonable. Some might favour the mortgagor while others might favour the mortgagee. But if all or even most of these considerations are deliberated carefully, it would lead to a fair decision for both parties. Thank you.